Morning, hello, and welcome. If you are a student curious about how privacy laws are shaping the digital economy, or a professional navigating compliance in your industry, or a business leader responsible for safeguarding user data, this series is for you. In this video series, we'll explore India's landmark Digital Personal Data Protection Act 2023, a transformative law that defines how personal data is collected, stored, used, and protected in a digital era. But we are not just scratching the surface. This is a deep dive across 8 focused parts where we break down the impact of the DPDP Act on some of India's most data driven and compliance sensitive industry, namely the BFSI sector, where consent, risk, reporting rules are redefining how banks and insurers operate. We look at IT service industry where global delivery centers must align with both Indian laws and client expectations. We'll then look at the healthcare sector where patients' rights and sensitive data demand ironclad protection. We look at the hospitality industry, wherein managing trust, identity, and personal preferences of millions of guests is paramount. We'll then look at the educational sector, where children's data is at the center of privacy enforcement. We'll then touch base on the world of marketing and sales, where consent is now the backbone of every outreach strategy. And finally, the social media industry, navigating new restrictions around profiling, tracking, and child safety. So, whether you are preparing for compliance in your organization or simply want to stay informed, this series is designed to simplify the law, contextualize the impact, and guide you through practical next steps. So, grab a cup of coffee, stay tuned, and let's together decode the DPDP Act one sector at a time. Morning and welcome. Let's now look at part 7 of this series. In this, we will cover the impact on marketing and sales sector from Digital Personal Data Protection Act perspective. As part of this video, we will be looking at starting off with an introduction and why this sector is directly impacted, roles under the DPDP Act, key obligation impacting marketing and sales, typical marketing use cases now at risk, challenges for marketers and sales team, practical implication by channel, strategic opportunity, actionable compliance steps, penalty risks for marketing violations, and we will conclude by going through a compliance checklist for the team on how they can work and get into line with the requirements of DPDP Act. And we'll conclude. Starting off, why this sector is directly impacted? Well, the marketing and sales sector thrive on personal data for lead generation, targeting, engagements, and conversion. This includes names, emails, mobile numbers, purchase and browsing history, location, preferences, and device usage. Also involves behavioral profiling, cookies, pixels, and ad trackers. Includes customer segmentation and personalization algorithms. The DPDP Act introduces legal restrictions on how this data are collected, stored, processed, and used, especially when consent is lacking or misuse occurs. Let's look at some of the roles under the DPDP Act. The brand or seller is considered a data fiduciary as per the DPDP Act. The marketing agency or the CRM provider are considered as data processors because they process data on behalf of the brand. The large advertising platforms are considered as significant data fiduciaries. This is based on data volume and impact on users. Moving on to key obligation impacting marketing and sales. Well, from now, all marketing communication will require explicit consent. They must explain why data is collected and how it is used. Data collected for one offer can't be reused for others without specific consent. The user must be able to unsubscribe or opt out easily. They cannot profile or target users under 18 with ads. Any data leaks involving lead database or ad tracking must be reported to the board and users. Complaints about misuse or spam must be resolved promptly. A typical marketing use case, which is now at risk. First is the cold calling from purchase list. This would be likely illegal without prior consent. The WhatsApp and SMS campaign, this would require opt-in consent and unsubscribe mechanism. Email remarketing without consent can be penalized under consent exists. Behavioral ad targeting, well, this must be consent based and no default opt-ins are allowed. Retargeting minors are strictly prohibited. Now you see how the game has changed here. Till now these were uncontrolled. With the DPDP Act coming into play, there are restrictions and penalties for violations. Challenges for marketing and sales teams. Let's look at that perspective. Well, buying, scrapping data is non compliant without consent with DPDP coming into play. They may contain outdated or unverified consent histories. So, that is something that the marketing team and sales team would have to look at. Outdated data, if it is, there is a violation which is potential hitting a penalty. Data flow and responsibilities must be clarified. They must be privacy aware and include unsubscribe and tracking limits. Teams must support access, correction, and deletion request quickly. Now, all of these challenges need to be addressed as part of the DPDP Act's base requirement. Let's now look at the practical implication by channels. When it comes to email and SMS marketing, they must offer opt-in checkbox, not pre-ticked. It should be an opt-in checkbox which the user can choose, not auto. They should include easy opt-out option in every message. And the requirement is to retain proof of consent. It's not that it is assumed there is consent. The burden of proof will be there on the organization which is involved in the marketing. When it comes to telemarketing and cold calls, it's allowed only with prior recorded consent and must maintain D&D, that is do not disturb, and grievance record. When it comes to social media and ad tech, they must avoid targeting minors. Track cookies, pixels, and data sharings with platforms like Meta and Google should stop. They should reconfirm data usage agreement with third party advertisers. When it comes to e-commerce and loyalty programs, they must collect separate consent for promotion, feedback survey, data sharing with partners. They can't use transaction data to market new product without specific consent. Let's now look at the strategic opportunity. This helps to build, once you are aligned, this would help to build trust, customer loyalty, and improved conversions. This would help to personalize reach based on privacy choices. It's a great differentiator in B2C and D2C sales. It focuses on quality, that is permission data, not quantity. From an actionable compliance step perspective, you need to implement explicit opt-ins for emails, SMS, WhatsApp and phones. You need to audit website for tracking technologies, enforce cookie consent, banners. You need to revalidate leads and remove non-consented records. The sector needs to update agency affiliated contract to reflect DPDP roles and responsibility. Sector needs to centralize unsubscribe, do not contact flags across all its tools. They would be required to assign a point person for DPDP compliance, especially for grievance redressal. They would require to educate on lawful outreach practice and red flags within the agency for its employee, part of their training strategy. Let's look at penalties for violations. Sending unsolicited marketing, well, treated as a consent violation. Penalty could be up to 250 crores. Using data of minors, considered as a special category breach, up to 200 crores of penalties would be attracted. Not responding to opt-out request, violation of rights. That's how it has been seen with heavy penalties. Failing to notify a data breach can attract fines plus reputational losses. Let's now look at a compliance checklist for marketing and sales sector, covering digital, traditional, D2C, B2B, and EdTech driven model. This checklist is structured to help marketing teams, CRM managers, agencies, sales ops leaders, ensuring end-to-end compliance across all data touchpoints. So now let's look at it one by one. We start off with governance and responsibility. In this, the first step towards is to appoint a DPO, a data protection officer, or designate a privacy lead for marketing and outreach operation. You are required to form a cross-functional privacy risk task force involving marketing, legal, CRM, IT, and agency manager. You are required to classify the organization as a data fiduciary or evaluate for significant fiduciary aspect. So, are you an SDF? That's the objective. That's something that you have to evaluate. You need to document responsibility, roles, accountability across internal team and third party partners. Once this is done, you move to the second part, which is audience data discovery and classification. In this, you need to audit all data sources, which includes email subscriber list, social media leads, contact forms and chatbots, purchased lead list. You need to categorize data into personal, sensitive, children's data. You need to document data flow maps from collection, storage, use, sharing or deletion. Once done, we move to the next phase, which is consent and privacy notice mechanism. In this, you need to implement explicit granular consent at all data collection points, whether it is website forums, event registration, product demo, or white paper download, or WhatsApp opt ins. You're required to display clear multi language privacy notice describing why data has been collected, how it will be used, who it will be shared with. You need to avoid pre ticketed checkbox or forced consent. The next aspect is opt out, unsubscribe, and consent withdrawal. In this, you need to provide opt out links in marketing emails, SMS message, WhatsApp communication. You're required to maintain centralized suppression list across all systems and platforms. You need to honor do not contact and unsubscribe requests within 72 hours. You're required to ensure users can revoke the consent via self-service portal or support. Let's now look at channel specific compliance requirement. When it's about email campaign, you need to use opt-in list only. You need to include clear unsubscribe button. You need to retain consent audit logs. When it is about SMS and WhatsApp, you need to collect opt-in via web or forms. You need to provide stop unsubscribe commands. You need to record time and method of consent. When it comes to telemarketing, call only DND cleared numbers. You need to retain call recordings for consent proof. When it comes to edtech and cookies, you need to display cookies consent banners. You need to block non-essential trackers by default. You need to avoid cross-site profiling without opt-in. When it comes to children and minor, do not profile or target users under 18. Implement age gating mechanism where relevant. The next aspect is CRM and lead database hygiene. We are required to audit CRM for non-consented contact, duplicates, and outdated consent record. Re-permission users where consent is unclear or dated. Tag contacts with consent status and preferred communication channel. Auto expire leads who haven't interacted within the retention window. The next aspect after this is agency, affiliates, and vendor oversight. In this, you need to review contracts with advertisement agencies, affiliated partners, marketing automation vendor. You need to insert DPDP specific clauses which include consent sharing and record keeping. Right to audit, breach notification obligations, and avoid data broker or lead gen firms lacking documented consent trace. Once done, you move to training and awareness for sales marketing teams, which include conducting role specific training for email marketers, content writers, paid media managers, and sales executives. You need to educate on what constitute personal data, when to seek consent, and how to respond to a user rights request or privacy complaint. You need to run periodic quizzes or awareness campaign on ethical outreach practice. Post this, you need to touch base on security and breach preparedness. In this, you need to encrypt and secure all marketing databases, use secure file sharing when sharing list or data with partners. You need to monitor suspicious download or export activities from CRMs. You need to develop a breach response plan which includes 72-hour notification to the board, customer communication workflow, root cause analysis, and patching. When we reach out, the next phase would be grievance redressal system. In this, you need to create a dedicated contact for privacy issues, assign a team to respond to complaint within 30 days. You need to log nature of complaint, resolution date, root cause, and process correction. Once you have addressed this, we move to the last part of checklist, which is monitoring and audit. In this, you need to maintain a marketing privacy compliance dashboard which tracks opt-ins versus unsubscribe, complaint volumes, breach history, consent status by campaign. You are required to conduct quarterly audits on campaign compliance, data quality, third party handling. You need to periodically test systems for opt out failures, consent gaps, and DNC non compliance. I hope this checklist would have given you a perspective on how you can navigate the requirements from the DPDP Act for your space. Let's take a sector by sector look at how the DPDP Act 2023 impacts different industries. Because compliance isn't one size fit all. I have compiled a comparative table covering BFSI, IT services, healthcare, hospitality, education, marketing and sales, and the social media industry. So let's break it down. Consent management. Well, consent is the cornerstone of DPDP Act, but its implementation varies. In BFSI, consent must be tightly managed, especially for KYC, biometrics, and financial information. In healthcare, it's even more sensitive. Patients and parents' consent is absolutely critical. For marketing and social media, consent isn't just required, it defines whether your outreach is legal or violation. When it comes to children's data, this is where the act is more stringent or most stringent. Educational institutions and social media platforms are directly in the spotlight here. Under DPDP, profiling or targeting anyone under 18 is strictly restricted. And verifiable parent consent becomes non negotiable. Do note, verifiable. The organization need to have a mechanism where it can prove that the parental consent was indeed from the parent. Next, on the data rights enablement perspective, all sectors must now empower users to access, correct, or delete their data. That means banks, schools, hospitals, hotels, and even digital marketers need process and tools to honor these rights, preferably through user friendly portals. When it comes to breach notification, every sector is now bound to notify the Data Protection Board, and in most cases, the affected individual within 72 hours of discovering a breach. In healthcare, this could be patient's record. In hospitality, it could be passport scan. Or for social media, a profile leak or consent compromise could trigger serious reputational and legal consequence. When it comes to third party or vendor risk perspective, here's where the rubber meets the road. Whether you are a bank outsourcing IT, a school using a learning app, or a marketing team working with an agency, the DPDP Act expects you to own the responsibility for your vendor's privacy posture. Data processing agreements and audits are no longer optional. They are essential. When it comes to grievance redressal, the DPDP Act mandates every organizations to have a clear, accessible grievance mechanism. This might look like a chatbot, an email, or an in-app feature. And it's especially critical for social platforms, hotels, and edtech apps that serves diverse digital first users. Well, likelihood of being classified as a significant data fiduciaries? Well, lastly, we assess the SDF risk across sectors. It is high for BFSI, IT, healthcare, and social media because of the sheer volume and sensitivity of data they process. For educational and hospitality, it is medium to high, especially if you are running large networks. And for marketing, if you're handling mass personalization and cross platform tracking, the risk goes up fast. So, as you can see, while the principle of the DPDP Act remains universal, the real world implication differs greatly depending on the sectors. Some industry will need to overhaul their tech infrastructure, while others will need to fix their lead generation or outreach tactics. But for all of us, it's a journey towards being more transparent, ethical, and user centric data practice. In the next part, we'll deep dive into each sector one by one. So stay tuned and don't forget to like, share, and subscribe if you are finding this series helpful. Do note this slide we will come again and again on all the modules that we are going to discuss. So, in case you have missed out or you need to have a better context, so when we look at BFSI and IT services and all the other areas, we will refresh this slide again and the context. In conclusion, DPDP compliance in marketing is not about checkboxes. It's about creating trust driven, transparent engagement. Marketers who respect privacy can build better relationships, avoid costly penalties, and align with global data ethics. Under DPDP Act, consent is king and privacy is power. The marketing and sales sector must shift from volume driven outreach to value driven engagement. Need to build on trust, transparency, and choice. Early adopters will enjoy stronger brand loyalty, reduced risk, and better alignment with global privacy conscious market. With this, we have come to the end of this video. We covered the agenda as we had listed earlier. We will now move to part 8, wherein we'll cover a new sector which is impacted due to DPDP Act. We will discuss how you can navigate, what is that you would require to get things in place so that you are in compliance and you can take the benefit of the act. This is your host Savit Vittal Salian, and I like to thank you for the time that you have invested. It's much appreciated. If you think this has added value to you, added value to your table, helped you with your organization strategy, do like and subscribe. So the next video, once uploaded, you get a notification and you can participate or engage with me. If you think there are people or teams who can benefit from this video, do share it with them so the knowledge can be spread across and more people can benefit. I'd like to thank you again. See you in part 8.